and welcome to Trial Tutorials, dealing with bad facts and bad witnesses. I'm Ala Policastro, CLE advisor for the Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Daniel Kramer and Teresa Johnson. Daniel Kramer is the founder of Kramer Trial Lawyers. He specializes in representing families and individuals involved in catastrophic personal injury and wrongful death matters, as well as employment discrimination and retaliation lawsuits. Daniel's verdicts on behalf of his clients have been featured in multiple legal industry publications, such as the Daily Journal. 5 of his verdicts were ranked as the top 50 verdicts in the state of California multiple years in a row by Top Verdict. Daniel has been a finalist of CALA's Rising Star Award and has received prestigious top attorney awards from numerous publications and organizations, including Super Lawyers and Best Lawyers in America, just to name a few. He is a frequent speaker and published writer on topics related to advanced trial and litigation strategies, and he chairs the personal injury section of Beverly Hills Bar Association. Teresa Johnson is a trial lawyer and partner at Kramer Trial Lawyers, practicing in the areas of plaintiff's personal injury, wrongful death, and employment litigation. Many of the verdicts Teresa has secured on behalf of her clients have been ranked by Top Verdict in the state of California and across the nation for the respective years in which they were obtained. Teresa serves on the Board of Governors for CALA and was a finalist for the CALA Rising Star Award in 2021 and 2023. Teresa is also on the board of directors for the Los Angeles Trial Lawyers Charities. She's a frequent speaker and published writer on topics related to litigation and advanced trial tactics. We can't wait to hear what they have to share with us today, so let's get started.
Thank you very much. Welcome, everybody. Thank you for tuning in on this great series of programs BHBA has. So we're going to dive right in. I think there's an important distinction before we start is that this program is going to be about bad facts, but not about bad cases. So, and I think there's an important difference that, I'm sure I have bad cases that end up not being good cases or righteous case. I mean, they all start out righteous, but it turns out that maybe some evidence comes out or a witness says something or a client does something that we thought was true and up not being true. And then it sort of becomes a bad case and a case that either should settle or it just really shouldn't be moving forward to trial. So this tutorial is not going to cure your bad cases, but it will hopefully help you deal with facts that, traditionally or maybe in a vacuum seem like, quote, bad facts, but actually can be told or framed in a way that they become just part of your client's story. And I think especially nowadays, and I know this is not just to plaintiff lawyers, this is to both sides and all different types of practice, not just personal injury or employment. It can apply to a business case or a contract dispute or who knows what criminal case. But, I think that nowadays what I find is that, well, one, we all know there is no perfect case. There is no perfect client. There is no perfect person. And I think in today's world, even more so, it's almost like the too perfect client or the too perfect defendant, too perfect company almost doesn't seem real to a jury any longer. And so in a way, showing vulnerability or showing the rough around the edges client or human story can actually make them more relatable to a real jury. And I find that some of our best results have been with a client that, has some warts or maybe some skeletons in the closet. And as long as we are open and honest and upfront about them, then it no longer becomes a bad thing. In fact, it makes that story a jury, many jurors, because everyone has shit happens to them, bad things in their background, tough situations. No one's perfect and no jurors are perfect. And so then there's something that they can now connect to as long as we as the attorneys have been upfront, completely transparent, open, and honest about it, that, it actually can make for a good fact and a good story. So even though the episode is titled Bad Facts, I want to be very clear that it's all in quotes, and we want to help you rethink about these things that you're scared of that keep us all up at night, because we all have them. Teresa and I just finished a trial last week that had a lot of quote unquote very tough bad facts that we had to overcome, but we did it by being open and transparent about it. So that's really how we're going to start. Teresa, let's get started. Here, I'm going to share my screen, and if you have any questions and anything you want to throw in there, please do so. When I'm not talking, I'm going to be monitoring it, and we'll throw it in there if it applies. And Teresa's going to be doing the same. So please feel free to do it. How you doing, Teresa?
Doing really well. Thanks for having us, everyone. It's nice to see you all. One thing I just want to add real quick before we start, Dan, is this all really starts from being open with your client from the very beginning and making sure that you have that trust. So you're getting all of the bad facts from the very beginning. By the time you get to trial, which is what we're focusing on, none of this should be a surprise. You should know everything, and you should know it well before the defense does so that you know how to combat it in litigation and all the way up to and including during trial. So make sure that you start that from the very beginning in your relationship. Get all of that information, the good, the bad, the ugly, so that you know and you can be prepared and one step ahead every single way, all the way up through trial.
Yeah, that's a really good point. And I think it's hard, right? I mean, our clients, again, whether you're on the plaintiff or defense, they're scared to talk to attorneys, and they're in this situation not by really choice at all on either side. And so to be open with your client initially to get them to give you all the bad stuff, because it's hard for any of us, frankly, like whether you're talking to a friend, a spouse, therapist, doctor, we like to sugarcoat everything because we don't want to look bad in anyone's eyes. And so it's hard to get a client, especially to an attorney, to say, like, just give me all the good, bad, and the ugly. We do not judge. And sometimes that takes us being vulnerable. This is what we do in jury selection. Like if there's something about you that may seem like a weakness or a vulnerability, share it so they will connect with you. And a lot of times those personal stories will get the client to trust you, like Teresa's saying, in order to get those quote unquote skeletons or bad facts. So with that, let me share my screen, and we're doing we did this last year, but we're going to apply it. I know you all have been focusing on this Nathan Taylor versus Vacations by the Sea, and we will be talking about those facts. We've added some to make it a tougher case for the plaintiff. Like, I think we made the guy a drug addict. He has a felony conviction. He may be an undocumented immigrant. We're not really sure. We just threw some really tough stuff about this guy, about our boy Nathan Taylor here, that makes the case a little harder, because I want you all to see how we would deal with these tough facts, and how we really frankly have in most of our trials, because we've dealt with a lot of tough facts, tough clients. Because what you start to see is there are pattern forms, and the pattern really becomes like, okay, this bad fact, how you handle it is going to be very similar with every type of bad fact. So this may be fact specific, but you can really apply the same blueprint for all of your type of cases. And we're going to use kind of a movie theme. We did it last time, and so we're going to use some movies. So maybe you might recognize some of these. All right, so let me hope I can share here. There we go. That's obviously us. We don't need that too much longer. So bad facts, like we talked about. Got Hannibal Lecter here to talk about the bad facts, because every client deserves a defense. Even Hannibal Lecter deserved a defense. But let's talk about some bad facts we want to create or had for this case. So our guy Nathan, he before he went on this cruise, before he met his wife, he got in some trouble, at least in our little hypothetical. And let's say when he was 18, I'm literally just making this up right now, but did some carjacking with some buddies in college and was charged with a felony. It's going to come into evidence. So that's another point for this little scenario, is that, one, you always try to mill out the bad stuff. So we're not saying, like, if you can keep out the felonies, do it. If you can keep out drugs and alcohol, do it. If you can keep out any of the bad stuff, 100% try to do it first. Do motions in limine. We do motions in limine for all the bad stuff, because it's a lot better not to have to deal with it. We're assuming for this scenario that it's coming in, but I do want to make sure that you all for all the bad stuff, do a motion and eliminate, because frankly, a lot of this would be, and a lot of stuff we deal with should be irrelevant, but we just are assuming that a judge is going to deny your motion and eliminate. In the case we just tried, our client had some wine before the incident. It was a premises liability case, a tough kind of trip and fall case where she fell and had a concussion, mild traumatic brain injury. But there was evidence by her own admission that she had some wine before the incident, which kind of goes to our next slide. And that, but the hospital record said that, she really didn't have any, there was no evidence of a BAC at all. The alcohol tests were normal. And the defense didn't have any expert who could say that her drinking wine that she was impaired because she drank like a glass of wine a couple hours before, or half a glass. Obviously, the defense wanted to bring it in, but what's the relevance if they don't have an expert who's going to say that in any way contributed to her fall? We have the hospital saying she was definitely not above the legal limit. She didn't even have anything show up. So the first thing we did is mill it out, and the judge saw through it and said, yeah, like, what is the relevance? It's, more prejudicial than probative. So stuff you want to do motions eliminate. And Teresa's a fantastic writer. We have motions eliminate for most bad facts, don't we, Teresa?
Probably,
Yeah.
or they could be modified. So if anybody
Yeah.
needs samples, don't hesitate to reach out.
Yeah, 100%. So our guy Nathan, not only is he an ex-con, he also, he was drinking and partying on the cruise ship on the day of the incident. So had to deal with that. We also, in this one, this is not a fact we made up, but it comes up in a lot of personal injury cases, is where you have a plaintiff who is, needs medical care, and they go to the attorney. The attorney then sends them to a doctor. Now, let me tell you this for all my plaintiff brothers and sisters out there. I do not recommend you do this unless your client really needs it. So, what we see a lot is that attorneys just get the case, and the client may have great insurance, great primary care physicians, people they really like, they've been going to for years for every other ailment, and then the attorney may scoop them out of that, and then send them to lean doctors. Now, I think lean doctors are great. They do help people that can't afford treatment, and they delay their pay for years often at times. And there's ways that we do it in closing argument where we flip it, and I can talk a little bit about that to make it more of a class argument that the defense is trying to make. But I just do recommend that you always try to have your client treat through their own insurance first, no matter what. And it really should be a last resort situation where the client really can't get care, maybe they don't have good insurance, that then you say, look, here's a list of doctors that I recommend that I think will treat on a lien, and then you let them decide based on their own research. It's cleaner, it's better, frankly, it's better for your client if they can go through their own insurance, they're happy with their own doctor. It's much better at trial. It takes away this bad fact from the defense.
Oh, looks like
Hello. Um, Daniel, it looks like the
List.
Zoom session had some sort of lag. If you could begin your this maybe about the start of this slide or so, just so that we could maybe, go back and
Sorry about that. So what I was saying was that just if you are a plaintiff attorney, doing attorney referred lien treatment is a last resort situation. If they have insurance, have them go through their insurance only if they've tried exhaust every other, avenue to get care, then you would want to give them a list of doctors who would treat on a lien that would be good doctors. But nonetheless, the defense or the other side, especially in this Taylor versus Vacations by the Sea case, they're going to argue it. And initially, we do a lot of focus groups. Focus groups hang on this kind of stuff. They think it's all a conspiracy, that it's ambulance chasing, it's build up to rack up medical bills and all that. So it is a tough fact that we have to deal with, but we also just have to reframe it, because at the end of the day, if you really just fundamentally sit down and think about it, the doctors are delaying payment for much longer than a hospital would, or maybe a insurance PCP would, years, to people that may not be able to afford the type of best surgeon in Beverly Hills. But now this indigent plaintiff is able to get the best care because these doctors are willing to say, you can pay me later. Don't worry about it. I want to give you care now. And then we flip it on the defense and we say the defense is saying, especially if it's a corporation, we say, guess where the CEO of this defendant's going to go if they have spinal issues? They're going to go to the best doctor in Beverly Hills. They're just going to do it. They're going to find and pay for the best. But they're saying our client should get below average care, do the Medi-Cal thing, and really just, this is way too expensive for someone like them. That has a lot of power in and of itself, especially in today's world. I've used that argument at trial for our client was a Mexican immigrant who didn't have any insurance, couldn't afford anyone, had to go to the clinic if he had problems. And the defense tried to use that argument and the jury hated it because we made it a whole class argument. So there's ways to flip this, but I just recommend when you're working up a case to do it the right way to take away the defense power. So, in this case, keeping with the movie theme, our boy Tom Cruise right there, we're talking about assumption of the risk. Nathan Taylor, the tough facts in this case is that, he's at the pool. He sees everyone belly flop. He decides to do a little different one. The defense is going to argue like, yeah, I mean, sure, we were hosting it, but this guy assumed the risk. So you got to talk about, obviously, you want to frame it from, it's like with the alcohol too, right? It's that the cruise ship, and we've had many cases where we've had drunk clients, but what we find when we go into the marketing of the defendant, it's like their whole promotion is alcohol. Go party, we're the party ship, we're the party cruise, we're the party hotel, come drink, have fun. I find every single advertisement where they have like champagne glasses clicking or half off drinks, happy hour, they show a real party environment. So, it's reframing it to say that, yeah, our client may have been drunk, but they weren't getting drunk and then getting behind a wheel. That would have been irresponsible. They were at a place they thought was safe to consume and drink and have drinks. And the bartenders encourage drinking, and they're offering shots with every beer, and they're coming around pouring shots on the cruise ships, on the passengers' mouths. So all this stuff. So then it becomes like, well, if your guest, and they are guests, especially here, it's a common carrier, that they're going to get drunk and drink, then you need to be extra vigilant because drunk people who are spending money to buy drinks are going to get drunk. So you have to be extra careful, especially when you're encouraging them to drink, and then you tell them all, come on, do this belly flop contest in the pool, knowing they're drunk. You never said only sober people can do this. So you then kind of flip it on them. And like when they turn around and point the finger back at the drinking, ask them, how much are you making from the alcohol? So that kind of thing. So assumption of the risk was one of the other bad facts we saw in this case. We're also making Nathan kind of an asshole. He's just kind of a jerk. He just, doesn't come across that great, but he really is injured. So that's just another thing you got to deal with. A client who just comes across kind of hard shelled, so to speak, or, kind of short tempered. He just doesn't seem that friendly. And this is where what Teresa is going to talk about is really kind of, there's a reason they're like that. And it's really getting to the root of why they're like that. Another one, I don't know whether it applies to Nathan Taylor or not. I did want to bring up an undocumented plaintiff because they have rights in our legal system, just like anyone else in the tort system, at least. And unfortunately, their rights are going away quickly, as we know. But they do have rights in the tort system, and so how do you kind of deal with that? And this can also be combined with someone maybe doesn't speak English, and I don't want to even call that a bad fact, but it is a fact that some jurors are going to be biased against. And so this program could be called bias inducing facts as well as bad facts. Kind of probably bias inducing is more appropriate, but someone who's undocumented, maybe someone who's lived here for 30 years, doesn't speak English, someone with a strong accent, maybe where they're from, all these things. This all would be combined kind of under like what would be a bias be, and then how would you overcome that? So the biggest thing is, like Teresa said, with the pretrial workup. And Teresa, I want you to talk a little bit. I know you're going to talk about direct exam later, but if you can go into a little more detail about what your method is, kind of to find their story, and before you get there, I think one thing to think about is, you know, in so many of these shows like Tony Soprano, Mad Men, Breaking Bad, all those, um, you have these guys who do some bad, terrible things, but as the audience, we all end up rooting for them at the end of the day, and we root for them to succeed. And so, obviously, in the history of storytelling, this has been a common theme. They're not always the hero's not always the perfect person. They're not always Clark Kent or Superman. Oftentimes, they're real human beings. And in a way, sometimes you connect with them more based on their weaknesses or their character flaws because we see some of those flaws in ourselves. Obviously, I don't think we're anyone on here is as bad as Walter White, but or Tony Soprano maybe, but I just think it's like that can create a bigger connection with a jury, but it's a matter of just getting them there, and that's where we talk about learning their story. So, Teresa, why don't you tell us a little about what your method is for really learning the client's story so that we can overcome those bad facts?
Yeah, I think it starts early, right? This isn't something that you leave right before trial's happening. You have to start early and really develop that relationship and that trust with your client. And so there's kind of two parts. First is your relationship with your client and getting to know them. Clients, everyone, they're all people. They're not going to be people that you might want to be friends with right away or people that you connect with right away. But there's always something you can learn about your client, and that's just from talking with them, spending the time with them, really getting to know them, that you're going to be able to connect with. And I think that's really important because sometimes on the surface you could look at somebody and say, oh, they're kind of strange, or maybe, I don't know, I really just don't get them or I don't understand them. But that's on us as the attorneys to be the ones to find that out and, like this says, learn their story. And that's starting from way back. So when we're prepping clients for trial, we're learning their entire life history. We spend hours and hours with them, meeting in person if we can, going to their homes to see where they live, and just really learning from day one, who are they? Where did they come from? What is their family like? How did they grow up? And spending the time. Often I'll have these meetings for weeks before I'm even talking about the incident and really prepping them for trial because I want to get to know who they are. And you always are going to find something about what makes them click, what makes them unique and special, and something you're just gonna connect with in a way that you're gonna be able to convey that to the jury ultimately. We had this trial that we just finished. On the surface, the client, she's kind of scatterbrained. I mean, she has a traumatic brain injury, but you talk to her and you're like, I don't really understand. But the more time I spent with her and I got to know her history and her background, where she grew up, what she did for work, kind of just like what kind of motivated her, it really gave me an understanding and for her in a whole new way that I was able to bring to light for the jury, I think, during opening statement, but also during direct of her, because I knew who she was, just at her core, what kind of drove her. And for this client, it was her love of music and piano, and that was something we really developed over, I don't even know how many hours I spent with her, but it was a lot. The other part, I think, too, is talking with friends and family or coworkers or people in their life to kind of get that second opinion as to who they see your clients, because you'll get to know your client, but you'll get to learn a lot more from talking to people in their lives too, who've seen the changes in them. And it's also just a nice way to see kind of some outside perspectives of the changes that they've gone through, but also the type of person they are. And it's always really inspiring to me too when you have so many family and friends who are willing to step up and talk about their experience with this person. Shows that this person has a lot of people in their life who's willing to do this for them, and that's really inspiring sometimes as well.
Yeah, just a couple things to add on, is that, you know, I know Teresa does too, like literally the first the first time we're really meeting with the client to prep them is that, like I want to start with the day you were born. And then like I'll talk about elementary school, like what their parents were like, their siblings, go into high school, like first jobs, like marriages, divorce, kids, like all those issues. Because like Teresa says, there's a story, a story, not all of it's going to be revealed at trial, certainly. The vast majority isn't. And to kind of play on the movie theme, like we are the directors who are going to have hundreds of hours of footage of film. And then our job is to edit it down to that final hour and a half, hour, 45 minute, 2 hour movie for the jury to see. Obviously, trials are longer than that. But my point being is that I just don't know where the story is, like the real story, like we represented a guy who was seriously injured, who was a meth addict, like in and out of homelessness, sort of, and so we had to like really learn his story and find out, about how he was, abused as a kid, and how that, like his dad, kicked him out of the house at like 11 or 12, and then he didn't have a choice to then go to the streets. But that then, when the jury hears that, because if they hear, oh, he's a drug addict, or he's had trouble, he's struggled with drug addiction, they just say, okay, they write him off. But if they understand like kind of where the root of it was, then it's like, okay, like that doesn't mean that he's not seriously hurt, or it doesn't mean the defendant should catch a break and get a discount just because the person they hit, has had demons. That doesn't mean they get a discount, and it's wrong of them to try to, throw this guy out like a piece of trash. That's just wrong. And then you make that the story, but you really got to find out, okay, what kind of led him to this path? What led Nathan Taylor to carjack, when he was 18, that led to the felony. So all those things, like this is why this is where it all starts, because so many of these facts, again, we're talking about bad facts, not a bad case. So many of these facts can be overcome, if not all of them, when you really get down to it. And then the defense, if you're doing a personal injury case or an employment case on the plaintiff side, the defense then looks like the asshole because they're attacking this person because of their skeletons. Why is that even relevant? Why does that even matter? Like what does that have to do with the fact that they were negligent and they caused serious harm? It's totally irrelevant. It has nothing to do with it. And then the jury's going to get angry at them. And so then, and then the jury, and you always want the jury to protect your client in your case against the bad actor. So I think like this is what we talk about, kind of flipping the bad facts. So someone asked, Ronnie asked a good question. Can't the information of someone being undocumented be quashed per motion eliminate? Yes, 100%. There's case law, and there's, that immigration status is not relevant to anything they say. And the judge will probably keep that out. I guess my fear and why we put that in there is because if jurors see someone, maybe they're a Hispanic client that has been here for a few years, doesn't speak any English, assumptions are going to be made. And that bias, even if the judge says you can't consider it, they're still going to consider it. And so it's something that you should, I'm not saying you should address it during your jury selection, but there's different ways to approach it to find out who are going to be my biased jurors who, are going to just believe that the plaintiff should not be given any money or should be given less money just because of their immigration status or just because of the language they speak, because that's a real thing you got to be concerned about, even if the judge does it on a motion in limine. So that's kind of the way we approach that. So another thing that I think is important on these bad facts is to do focus groups. We do focus this from our old office, but we probably do like 6 to 8 focus groups a month, and people hear that and they're like, God, that must cost like tens of thousands of dollars. It actually doesn't. We run them ourselves. We pay, usually $20 to $25 an hour, maybe 30, maybe a little more, like $100 for 2 hours, or it ranges, but we'll get 10 to 11 people just in our conference room. We'll post it on Craigslist. And then, so we're only paying for the money for the people to show up, and we test out, these kind of bad facts, and we see how the focus group will respond. And oftentimes we get a lot of our good sound bites and counters to this stuff from these focus group jurors, because they will say something like, what, like I just said, like, why does it matter if he had a felony? Like, what does that have to do with it? Or they'll give us like little vignettes or little, bumper stickers, like statements to say that we can then roll into our theme. So, because we're all attorneys and we all have this attorney mindset, it's almost better to present the bad facts to a focus group of a cross section of people and have them, you know, give you ways to kind of reframe the story. So we do a lot of focus groups. I think that's a really good way to test out these bad facts. You want to do it, especially before you get in front of a jury, because you don't want that to be, or especially during jury selection or your mini openings. That's usually where you're going to present your bad facts to the jury for the first time. You don't want that to be the first time you're testing out to see how real people respond to X, Y, and Z. So we do a ton of these. So let me talk a little bit about voir dire, because I think this is the most important part of where you have to address all this stuff, all the bad facts that are coming out. And the first place you do it is that you kind of start by, you want to establish what are your danger points. Every single case that we try, I usually sit down with kind of a blank Word document and I just write down like all the stuff that scares the shit out of me, that keeps me up at night about the case. Drinking before the incident, or doesn't speak English, 30 years living here, has two felonies, whatever. I mean, all the stuff. What else, Teresa? What other stuff we've dealt with so many attorney referred treatment, that we've talked about, maybe minor impact, maybe, had pre-existing X, Y, and Z. Who knows? Just all the stuff that I'm like, I know the defense is going to hammer. So I kind of put that as a list, and I'll start saying like, here it'd be, assuming the risk. The guy did a dive when he should have done a belly flop. We're gonna ask for millions of dollars. That's a bias point. That's a potential bad fact that a lot of jurors have a lot of strong feelings about. If you're on the plaintiff side. A non-corporate defendant. I know in this case you have a corporate defendant, and so this is for the defense attorneys on this. It's the anti-corporate bias that you got to be worried about. You have a huge cruise conglomerate, and how are you going to get jurors to understand that we're not just a cash register, and that even if we were worth billions of dollars, that you need to treat us like we're an individual. So, a lot of these bad facts we're talking about mostly from the plaintiff side, but from the defense, you got to worry about that. So how do you get, a jury to understand that, like, just because you're a corporation doesn't mean that you have to double what a reasonable amount is. But sometimes some of our bad facts is, Teresa and I have tried many cases where we've had like a grandmother on the other side who hit our client in a crosswalk, for example. And it's like, but we were asking for, $15-20 million or something like that, because there were serious injuries. And so how do I get a jury to be willing to appraise the value and sign their name to a verdict at $15 million when on the other side, it's like Betty Crocker? That's really tough to do, right? So that's a tough fact. It's not, I don't have Amazon over there. So that's something you got to kind of think about. You got to ask in jury selection. And then, an honest mistake, a lot of times in our negligence cases, like, we worry that it's an honest mistake, that it was just, they were trying their best, but they just, we all make mistakes. So that's kind of a fact that you have to deal with on the plaintiff side. Alcohol, we talked about, attorney referred treatment. So these are the things that, like, this is an example of how we kind of sit down and we'll write a list of the bad facts, whatever they are for your case. You're going to see how in jury selection you can, frame it in a way that is not gonna, and I'll talk about this, not gonna snowball too much negativity right out of the gate. But it's going to find out who are exposed, who are the bad jurors for you, and also who are the good jurors. So the first place you want to do this is in the mini opening. And in California, under CCP 222.5D, the trial judge must allow a mini opening from both sides if they request it. And so I always recommend you do a mini opening before your jury selection. And in your mini opening, there are kind of two schools of thought. I used to probably about 5 years ago. My thing was I want to make our case sound as terrible as possible. Just say like my client, Nathan Taylor, ex-con, was drunk and jumped into a pool head first and hit his head, and we are suing the cruise ship for $10 million dollars or $30 million dollars for causing his injuries. You say that, and you're going to get like, everyone's gonna be like, why are we here? Like, what are we doing here? This case sounds terrible. Like, how are you going to, and then you're going to get, a whole snowball of people who, are going to just think your case is terrible. And sure, within that wave of bad people, you will pick up very bad jurors that you'll get for cause. But the problem is you'll also get potentially really good jurors who you couldn't even find out if they were good jurors, but they just, the way you framed it in your mini opening so negatively that all of a sudden you could have lose some really good jurors that you think are bad just by how they're responding to that mini opening, because you didn't give them like a preview of coming attractions, for example. And, so in a mini opening, I have Walter Cronkite back here because you want to be very neutral. You don't want to be too negative, I think, because, again, like I said, you could lose some good jurors, but you want to be very matter of fact, certainly in your presentation. You don't want to argue your case, all the good facts. You want to leave your best facts kind of hidden. But you want to just present it that, you'll hear that, Nathan Taylor, he was on his cruise ship with his wife, and they had been drinking and having fun on the cruise, and he volunteered to do this belly flap contest that they all invited people to do, and he jumped in, whatever it is. I mean, whatever you want to do for these facts, but then you want to weave in kind of your bad facts that he didn't really have the ability to his insurance didn't cover a lot of the care. So he came to us, we gave him a list of some doctors to see. He went and saw these doctors who, have been treating him for a long time. And I want to be honest with you, he had a, kind of a rough upbringing, had gotten in some trouble, but had cleaned up his act. And you'll hear whether or not that really matters to anything you have to decide. And then so I would weave in the bad facts, but also say, and you'll hear whether or not, what the defense is going to say. They're going to say X, Y, and Z, that, he shouldn't have done this or they did nothing wrong. You'll hear from the evidence and the experts and decide for yourself whether that's even really true or not. So just keep an open mind, because you want to kind of leave them thinking like, well, maybe there is some more to the story, and you want to leave them wanting more, but hide the, your best facts, weave your bad facts into the story without making them sound like something you're apologizing for or that you're scared of. And then always say, you'll hear and you'll decide whether or not what they're saying is true. And you'll hear from lots of experts and medical records, and you'll find out what the real evidence is. And so that gives them something like, okay, he may have the goods, we just don't know it yet. So that's my new philosophy now. And because, my goal again used to be try to get as many cause challenges as possible on the bad stuff. But I just think it's not a stats game where you're trying to like just rack up all the cause challenges. I think it's really kind of how you frame things. You still get cause challenges. You still want to expose your bad jurors. I think there's a different way to frame that.
Just before you go to voir dire
Yeah.
real quick on mini opening, I think one thing that Dan said is really important is the weaving in of the bad facts. You're not hiding the bad facts, or you're also not just dumping all the bad facts out one after another. So it's kind of an art of how you're weaving them into the story, because you aren't hiding them either and not addressing some of the bigger ones, because the defense is obviously going to bring them up, or the other side is going to bring them up, and you don't want to be the one seen as hiding them or trying to make it seem better than it is. So it's about how you weave them into the story so that it's not just this bad info dump on the jury for the cause challenges either.
100%. I mean, again, in a case of tribe where the gentleman had been here 30 years, didn't speak English, and we'll say, I just weaved it in. I say, he came from Mexico in the 80s, and he's lived here for about 40 years, and he's going to testify through an interpreter. He only speaks Spanish. And then so I'll just say that and then go on and then say he got hurt when when X, Y, and Z happened. So it's a bad fact to me. I'm not highlighting it too much, but I'm definitely saying it. Teresa's 100% right. I gotta put it out there, the bad stuff, because some jurors are gonna like their ears are gonna poke up a little bit, if that's the phrase. I don't know, but they're gonna listen and they're gonna be like, wait a second, that seems kind of like, why is he not learning the language? And so I'm gonna get those bad jurors to tell me about that. But 100%, you got to weave it all in, but weave it in the right way as part of the story, and that's only if you learn their story. So for jury selection for bad facts, I kind of like a soft intro to a topic, and I'll show you what I mean by that. I think it's really powerful if you can, confess that, you know, um, either yourself that, you heard this is a trip and fall that happened at midnight, or, even on the Spanish speaking, I got to be honest. If that's the issue I'm going on with my set of questioning, it's like, when I first met, Mr. Jones or whatever, like he had been in this country for 30 years and hadn't spoke English. And I got to be honest, like part of me feels like if you're going to live here, you really should try, or at least learn the language, especially that long. Does anyone else feel that way? Because look, I've confessed to my feeling because it's a real feeling that I may have had. And a lot of these bad facts that we're talking about, most of us as attorneys, when we heard about it, felt like that's a problem or that concerns me. So why not just be honest with the jurors about that? Like, I had heard, we're talking about alcohol here, and he'd been drinking. And some of my first thought is that if someone's drinking, it's got to be, if they get injured, it's probably their fault. And I had that initial feeling. Did anyone else have that? And then so you kind of so I've been honest about my feelings. Anyone else feel that way? You find out, then you talk to them more, and then you give them other hypotheticals, like, well, what if it was at a bar or a football game? Like, do you think that companies should have to keep their property more safe for knowing that there's drunk people there, or should they just keep it safe for sober people only? What do you think about that? And so there I'm introducing kind of a new topic, and it's like the people that are going to say, no, it doesn't matter. It's not the company's responsibility. If someone's been drinking, there's no way it could be a property owner's or cruise ship's responsibility if someone gets hurt. I just can't make that leap. And then you find out more about that person, and maybe they'll say they can't be 100% neutral in this case. But it all starts with how you kind of massage the topic in. Again, if I just start out right away, like, who thinks people, who has feelings against people that get drunk and get hurt and, blame other people? If I start there, I could start with a snowball effect of people kind of coming at us like, well, yeah, of course. So let me show you kind of how we do it. I like to scale and kind of group. And what I mean by that is I'll say, for example, in this last case, I like to give the jurors an option of where to lean so they don't have to be locked into one side. So I'll say, some folks feel that property owners or property managers should always be on the lookout for safety hazards to prevent an injury. And then I'll walk to the other side of the jury box, and I'll say others feel that that's too high of a burden. And property managers, property owners have a lot they have to deal with, and they really should fix things when there's a complaint or someone's already been injured. And then I'll go back to the middle and I'll say, who leans more towards that group that thinks it's too high of a burden? And so they're not forced to be in a box, but they can say, yeah, I kind of feel that way. I kind of feel that, people sue too much, or, property managers. And you'll find out the people who have either the property owners and they don't like these type of lawsuits, but they're not in a box. And so they should feel safe about saying, yeah, being open about which way they lean, because they're not putting themselves like, I am X, Y, and Z. I am this. They're not. They're just saying, I sort of feel that way. And human beings don't like being themselves put in boxes and labeled as a certain thing, because there's gray areas of all of us. And so, but I want to find out who sort of feels that way and then follow up with it. So, the assumption of the risk. So here's an example. It may not be right on point with this, but how, like, for example, say a motorcyclist you have a motorcycle case where the motorcyclist wasn't wearing a helmet, but they were severely injured with orthopedic injuries, no head injury, but it was like spinal injuries or leg injury, lost a leg, who knows, just anything below the neck. And but the defense and the judge is letting the fact that the motorcyclist wasn't wearing a helmet come in. So, and so one way, I think not a good way to ask the question about this bad fact is who has bias or disagreements with motorcyclists not wearing helmets? I mean, everyone, I think motorcyclists should wear helmets. I think every single person in the world agrees with that. So, but if I ask the question this way, and I made this mistake even this year, on a premises case, asking kind of about people's view of, slip and falls or where people should watch where they're going, because everyone agreed with that, and then it can turn into a snowball effect. And when I say snowball, I mean that everyone's going to agree with this, and then and then if everyone's agreeing to a bad fact of your case that that's a bad thing for you, then you're not really finding out the bad jurors. So maybe we frame it that you start off by saying, I think we all agree that motorcyclists should wear helmets, right? And then everyone raise their hand. But if a motorcyclist doesn't, and his injuries entirely his fault if someone else crashes into him, even if he hurts just his spine or his leg and not his head. And then you're getting so you're not asking to prejudge the case, but you're sort of reframing the idea that, the helmet doesn't really matter. The defense doesn't get a discount because of that. They can't escape liability when it really is not really, why does it matter? They're just trying to label this motorcyclist as just unsafe in general, even though the helmet or lack thereof didn't really have a big impact here. It's like if a drunk driver is rear-ended, does that make the drunk driver at fault just because he got behind a wheel when he was drinking? So you want to introduce these concepts, but do it in this way, because if you ask who has bias against people who drink and drive, everyone does. Everyone should. But it's really going to, how does that affect this? If someone has felonies, should they should they be compensated less because they have a felony? Or there's just, with every bad fact, you could just plug in your bad fact and do it kind of this way. The alcohol, drugs, here's another one. Who has biases against people who drink heavily or do drugs? And there may be, people that have those biases, but I think maybe the way to frame it is you want to see some people believe that when someone chooses to drink, even just casually, they are fully responsible for whatever happens next, no matter what. So this is where we talk about the scaling. And then I go to the other side. Other people believe while people are responsible for their choices, others around them, especially companies or hosts, can still share the responsibility for creating a dangerous situation. Who here feels that way just a little bit? Someone who drinks, what happens? So you see how we've kind of taken the same formula with whatever your bad issue is, and then you have framed it not super negative, and then you give them an opening to see both sides. And a lot of times what you'll start seeing, which is, I love it when this happens in my jury selections, is that you'll get that debate started, and you'll get people on this side, blah, 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 blah. And it's kind of a dance. And then you're just kind of like the maestro of it. And then you always want to follow up with who are the jurors that you think are bad for your case. All you have to say is well, thank you for sharing that. And you don't want to go right hard on cause right away. And you just say, does anyone else sort of feel that way? Even a little bit. And you'll have 3 more hands. You'll follow up with them. And they'll maybe say something new that's bad for you. Anyone else feel that way? And then eventually you'll work your way back down, and then they'll say other things, and you could probably then lock those, 5 or 6 bad ones for cause. But you only get there by kind of giving them that safe space to tell you about their bad feelings. Teresa, any thoughts?
No, I think that's all great. We have a question that's more if this is a bench trial and how you would address framing potential bias that a judge could have in opening, which I know we're going to touch on opening shortly.
Yeah, so in full candor, I don't think we've ever done a bench trial. But with that said, I don't see why it really should be any different. Judges are human beings too, and I think it's all about how you frame. And I'll show you here. It's all about how you frame this story and who is the protagonist, who's the main character, and the way you are telling the story. I'm a big believer. David Ball, who's a great author, I still do believe strongly in his teaching that you always frame the story from the bad actor's perspective the whole time. And if that could mean you go back 20 years. In this last trial, Teresa's opening, we kind of reframed it so that we were starting way back to how neglectful the property manager was. And then went ahead, that was like 30 years ago. And we jumped ahead 10 years and talked about when the dangerous condition was created and then how it was just left there and neglected. And then eventually on May 13th,
19.
2019, a woman, blah, 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 blah. And so I haven't even introduced the plaintiff until I've laid all that foundation of the bad actions. Because even in a passive negligence case, like most premises cases are, there always is a bad action. And like in our situation, I would probably, frame it from the cruise ship. And if you have these facts, how they sit around in the boardroom and they talk about, our bottom line, we really make a lot of money from selling alcohol and how, we really want to get you like push alcohol. And then I would set a scene where I would have the GM or the managers and all that talking about, wait, we got to push the booze, push the booze, push the booze, do this, do that. Like really, like I would just like make that the whole thing. And then eventually they're seeing where this is going to go. It's like, Romeo and Juliet, the jury already knows that there's a bad injury because you've said that in the opening, but they don't really know how we got there. And Romeo and Juliet, the first line that Shakespeare said is that, they both died. They both die at the end. So the ending and then it goes into the story, but the whole time the audience is listening and it's like, well, I know how terrible this is going to end. And that makes you even more like, it's just like such a powerful way to tell a story. And so, that's why you do the same thing with a judge. I don't know why it should be any different. You frame it from the bad actor's actions and walk through the story. And again, your story in your opening statement, as I'll show you, can start the day before, the week before the incident, a month before, 30, 40, 50 years before the incident. It could be an institutional problem. And so it's all about, so don't think your story has to start with the incident itself.
Yeah, I think Christine, just to follow up on that question real quick, think about how maybe you would do an opposition to a motion for summary judgment and how you'd frame the statement of facts. You're not just starting, or at least the way I tend to do them is I don't just start with the incident itself. I try and back up to lead up to how we got to the incident so that the judge has an understanding, like Dan said, of how you get to the final incident happening. Somebody else had a quick question about religious and ethnicity bias.
Yeah.
I think a lot of this that we've been discussing would apply the same way, right? You hit head on if you're concerned about those things, probably similar to maybe the immigration status issue or not speaking English, same type of thoughts and questions you could ask.
Yeah. So with that one, that like I get asked that one a lot, about my clients from the Middle East or Israel or who knows where. And like, well, obviously with everything going on, like it's something that we're worried that a jury is going to give less than for, or be just biased against. And I think a lot of times, I would not hit it head on with like, hey, my client is X, Y, and Z religion, who's biased against that, because no one's going to admit that. I mean, no one's going to admit they're a racist. They're going to say, I'm the least racist person there is, stuff like that. So you're just not going to get what you need. People are going to clam up. I think judges, if you kind of hit that hot topic right out of the gate, I think they will shut it down and they'll just they're like, you can't consider it. So I would either, approach it more of if they have an accent, different language, I would just kind of very softly approach it that way. And in terms of religion, it's a tough one. I just don't think I think a judge is going to shut that down. But and if it's really a huge hot topic, I would ask the judge for a questionnaire about it, because that's a safer space for people to write those things. And I think you can convince a judge to say, look, I have this very, I'm really concerned about this given things going on in the world right now. And, it's very obvious what my client's religion is. They have to either wear something or just whatever it is. And then you may want to just address it with a questionnaire, because you don't think people will be open about it in the public setting of your courtroom. You also tell the jurors if there's any bias that you may have that you don't want to share, that's okay. we can do it all in chambers, but please let us know what your biases are. And then, another maybe even better way to do it is that you just talk about their oath. And there's an oath they're going to take. If you get any hint that there's an oath they're going to take that, you know, they can't consider, sex, religion, sexual orientation, all those things. And, is anyone going to have trouble, following that oath? And then you may find that, which is kind of funny, is that, some people who may have those unfortunately racist or religious biases, they sometimes they take their oath even more seriously. And so there's different ways to approach it. It's a tough one. I don't have a one size fits all answer. I just would not come right out with saying my client is this religion, who's biased against that. I just don't think you're going to get that answer. So I would get the judge's guidance. I would try to do a questionnaire, and then I would, figure out, is there some way to find out who are the real biased people against someone from this country, maybe, or, and just try to like softball it in there. I know that doesn't directly give you an answer, but that's how I would do it.
Somebody else had a question about bias against trial counsel, if that's ever something that's comes up or gets addressed in front of a jury. And honestly, I don't think it ever really has, as like something where, either because of myself, as the question was specific to as an Asian American trial attorney, if that's something that I've ever addressed. And I've never brought that up in front of a jury before, or had that really brought up by jurors, I guess. Dan, do you have any thoughts on that?
Yeah, obviously I can't speak as an Asian American trial lawyer, but certainly my opinion is that these things that we worry about, I think the only thing that matters to jurors is if you're credible. I think it doesn't matter if you're a trial lawyer that has an accent, you're Asian American, you were born somewhere else, you're Middle East. It doesn't, I truly don't think, and I know I'm saying this as a white dude, which is like, take that for what it is, but jurors care way more about credibility. I mean, look at all this massively successful trial lawyers we have, especially in Los Angeles. They come from all shapes and sizes, all walks of life, men, women, doesn't matter, all races, all ethnicities, all that. So, obviously, if it was just, jurors only trust a certain ethnicity, I don't think they would be successful. So I do think what's the most important by far than anything else is just being credible and keeping your credibility. And that means being transparent and being brutally honest with all the bad stuff. Don't try to sugarcoat it. Don't try to hide it. Don't run from it. Just be honest the whole time. I think that's all jurors care about, frankly. Teresa, I don't know. That's probably the best way I can answer that.
Yeah, I'll be honest, it's never been something I've been concerned about, that a juror is going to treat my client poorly or not be as neutral or as impartial as possible because of who I am. I think the way that I try and see it is that the bad jurors are going to make themselves known for one reason or another throughout jury selection, where I don't have to really be the center of any of that attention about me specifically. And as long as I'm just being myself with them, I think that goes a long way. Just being who I am. And my style is very different than Dan's style in trial. But as long as I'm being authentic, that's my way to connect with the jury. And it seems to be working overall. The bad jurors will make themselves known for something else anyhow.
Yeah. And honestly, they'll be honest if they don't feel like they trust. I mean, they'll say that, be like, I just don't think I don't trust you. Or like, I encourage that. Like, give me all the bad stuff. Like, it's a personal injury case. Like, if like if someone says you're an ambulance chaser, or this is a money grab, I'm open with like, please tell me, or anything. Like, I want them to tell me that stuff. So let's talk a little about opening statement. I talked a little bit about kind of the way we structure things in a lot of our opening statements. We have, a kind of a soft intro. Either we'll say the rule or do some kind of one sentence introduction. We'll talk about what good, in this case, good cruise ships do, safe cruise ships. Talk about what bad cruise ships do, just kind of in the hypothetical and the not just directly tied to the defendant. And then at that point, we say we will go through the story. And this is, again, going back to where do you start your story? And sometimes it can be years before, like I said. And then the things we had to look into. This is a lot of this from David Ball. And so we do that. And then why are we here? Just really taking down the defenses, the loss, dismantling the loss defenses, who was the client, and then kind of the ask. So this is generally not all the time, but this is generally how we kind of frame our put our openings together. And where you're going to deal with the bad facts is really in these two sections here. The things we had to look into, you can either do it from the perspective of, look, before we came to trial, we heard our client was drinking on this cruise ship. So we had to see, like, was alcohol really the cause? Like, is it all on him? We had to look into that. So we went and we spoke with a toxicologist. We went and spoke with, cruise ship safety guy. I don't know. I'm sure that's the official title, but and they say, no, you're supposed to, and then they say, no, you're supposed to, anticipate drunks on a cruise ship. You're encouraging drinking. You got to be even more careful. Your safety has to be even to a higher level because people aren't driving, people are drinking. So you always got to be on the lookout and keep drunk people safe because that's how you make money, right? So I've taken the bad fact. I've had the question about it. I'm then sitting like a juror would, and then how we look into it. So that's kind of how we would introduce the bad facts, and then the story and the client before. The client before is really where you humanize who the client is. I do it really late in the game because I really don't want. I just don't even want the jury thinking about who my client is too early. I know a lot of people right out of the gate in kind of the introduction area will say, let me tell you, there's a story about Miss Smith, and she's from Tuscaloosa, Alabama, blah, 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 blah. And so I just don't know if people care at that point. Jurors are like, well, I'm from here, I'm dealing with my issues. So I, again, want to frame it always from the bad actor's perspective. And then hopefully by that time I've earned the opportunity for them to care about actually who my client is as a person. I think if you do it too early, I think people just kind of tune out. Everyone has a story and they're not invested yet. That's why I don't like doing it that early. So, these are kind of the things that I would probably bring up in my opening statement. I would massage them in, he was drinking. And then later on in the story, I talk about, kind of what he had a tough upbringing. He did this, he made, a lot of mistakes. I'm not going to sit here and tell you he's a nun or he's a priest. He did X, Y, and Z, and he did that. And he's turned his life around. He still has struggles, but you're going to hear, no one's going to say that made a difference in what caused his injury or anything like that. But I want to be honest with you about who he is as a person, something like that. Not apologize for it. Just be honest about it because it's part of who he is and it's part of his story. So Teresa, do you want to talk a little bit about direct exam?
Yeah, so I think it's really important when you have a client, maybe especially somebody who on the surface might not seem that likable, for example, or has maybe they went on a lot of vacations after the incident. Maybe Nathan goes on more cruises again after this incident happens or something. Those are things that can be brought up on direct examination and potentially through some of your other damages witnesses as well. So I always think of it as like you're using your other witnesses to paint the picture as to who your client is before your client even gets on the stand. And that includes both the good and the bad. So you use these other witnesses, your damages witnesses, maybe it's a partner or maybe it's a friend or family member, to kind of put into context some of those bad facts. So for example, if we think about maybe Nathan going on cruises afterwards, maybe you get his wife to talk about on the stand what it was really like for him being on those vacations, but why he decided to take them, if that's a fact that's going to come in at trial. It's not a great fact to know that he went back on all these cruises. But maybe the reality is that he took these trips because his family needed him to get out of the bedroom because he was just sitting at home all the time and he was in a really bad headspace all day. So you get the wife to talk about why they encouraged him to take this trip and what it was like for him. He wasn't going on outings. He was sitting on the cruise ship all day, just kind of being there, but at least it was a change of scenery. That actually happened in a case we had at trial last year. We had to talk about why she went to Panama after 2 months after she had been in this horrible car crash. But the reality was that she needed to do this and she talked to her doctors first. So we brought the story to life, the bad facts, through that. Maybe you have a client again who on the surface just seems tougher or is harder to understand. So you get somebody who understands him to talk about who he is and why he is the way he is. We had a trial this year where we had these witnesses talking about kind of how our client would navigate life before and why they were a hard worker, building up their character and their credibility, so that by the time that person, our client, got on the stand, it was understandable why he was a little rougher around the edges or maybe a little more tougher appearing than some other people would be. Because we had all these other witnesses who painted the picture as who he was before he got on the stand. So
Yeah. So
yes,
here's a
you
good,
would
sorry.
present all of these witnesses before you do the plaintiff. The plaintiff goes last or as close to last as possible. So you have already filled in this picture as to who they are before your plaintiff even says a word. And maybe you don't even have your plaintiff there at all during the trial, or you limit how much the jury's even seeing them so that the picture's really being filled in by your other witnesses. You can use your
Yeah. So
doctors
sorry.
to do this too. Oh, go ahead.
No. I was just gonna. I think that's an important point. I mean, we've done it many different ways. We've had the client there throughout the entire trial. We've had them there just for voir dire, opening, direct, and then closing. We've had them there just for voir dire and direct and closing. I think now we're settling on honestly not having the plaintiff there at all, except for direct examination. And I know that sounds blasphemous to a lot of attorneys out there. I just spoke on Monday in San Diego, and a lot of the older school attorneys were like, "That's crazy. You got to have your client." And like our belief on that, I think, is just that especially in a personal injury case, that the jurors are going to just judge and judge and judge every single thing that the client does. It's free sub rosa, really. And there's no, like, I just don't see anything good that's going to come out of them sitting there and looking at your client. If maybe the client's seriously injured and it's a obvious injury, they walk with a limp, they're in a wheelchair. Well, guess what? They're going to be very desensitized if they've been there the whole trial by the time they testify. If your client has invisible injuries, they're going to look and be like, they look fine to me. They don't look any different than I do. I look worse than them. So they're going to judge every little aspect of them. So to me, I just want to take away that the jurors, they don't know what the rules are. They don't know whether or not clients are supposed to be there, whether they're even allowed to be there. They may think they're not allowed to be there. It really doesn't matter. And frankly, judges will shut down if the other side tries to say, well, where's the client? It's not relevant to anything at all. And so our belief, I think, and again, this is stuff where it's always evolving. Our trial practice is constantly evolving, is that we just want the story, like Teresa said, to be built up through other witnesses. And then the plaintiff comes in and testifies. This last trial, Teresa did a phenomenal job. How long did you put the client on for?
15 minutes tops.
Todd, I thought it was 10.
Yeah, it might
But
have
it
been
was
10.
just it was just to the point. It was just and the jury appreciated it. Jurors nowadays also have very short attention spans. And if you're sitting there dragging out an hour and a half long direct talking about all the bad shit that's happened to them, and how terrible everything is, like, people don't like, whiners. And so I thought it was just a very powerful direct that Teresa did. But we did it by, developing her story ahead of time so she didn't have to carry that weight.
Yeah, and one other quick point, maybe you have a case where you don't have that many friends and family that you can even call as a witness. That happened in our last trial, and we were able to still develop the story through the doctor testimony, her treating physicians who had seen her for years, who could talk about how consistent she was, how credible, motivated she was. And that goes a long way too. So just think outside the box if you don't have some immediate family members that can provide that testimony. I do think it is helpful though, and maybe you don't even have family, but if you have acquaintances, we've used hairdressers before, we've used former partners like an ex-girlfriend, dance instructors, yoga teachers. It doesn't have to just be family members who bring this testimony.
In fact, it's better. It's better if you can have a 10-minute, the guy at the bodega. Well, it's not New York, but like, a guy that they would go get a sandwich from every single day. And he would see, your client walk in, walk out, everything was great. And then didn't see him for months. Next time we saw him, he was like, he's just struggling. You could just tell, look on his face. Like that 10-minute, 5-minute witness, 10-minute witness paints a much better picture. Here's let's see, we have some questions here, good ones from Joanna. How do you handle a bad fact that opposing side somehow brings up that you did not know about? Yeah, that's tough. That is like, this is why we do like everything we can. As soon as we sign up a case, we do a background check on our client. We do deep dive social media investigations of our own client. We tell our client, don't post, don't do this. And if you do, if you're deposed, be 100% honest about everything you've ever done. Don't deny anything. So I think the situation you're talking about happens to all of us. Happened the last trial. The defense has some kind of found from a friend of a friend of a friend was tagged, and then they were able to link that back to your client. It's tough. I mean, that is a situation where you're talking about real impeachment there, and that is very hard to overcome. You just have to constantly talk to your client about being honest. And if the defense is starting to go down a path on direct that you believe they are, trying to hang your client, like, well, did you do this in 2025? And it's like something like, whoa, where's that coming from? You prep your client and be like, if they start asking very specific questions, don't hide it. If you know where they're going and they're talking about something, just be honest about it. Because again, we as attorneys can't fix a client who's not truthful. We just can't. And so it's just making sure they know from the very beginning that you having a long history of neck problems, you going on this trip because you were severely depressed and your doctors told you to get out or else it'd be worse, that is not going to hurt your case. I can work with that as your attorney. What I can't do and I can't help you is if you're not truthful. If you lie, then I can't help you and I can't spin that to a jury. I just can't. And once we lose credibility, we lose the case. So, Joanna, I know, I don't know if that answers your question at all, but that is kind of how, how I would recommend trying to prevent that. Christopher asked, when Teresa had plaintiff in the box for 10 minutes, how long was the cross?
It was probably about,
30, 40?
yeah, 30 or 40 minutes, and then my redirect was pretty short as well.
Yeah. So Joanna's follow-up is, unfortunately, this has happened not to our client, but an expert witness we used. That they used to create fake 5-star reviews on their website, and it was very damaging. That's interesting. I've never had reviews be able to come in either way, whether they were real or fake or anything like that, because one, it's hearsay. And so, but look, I mean, this goes to the credibility. If it's a non-client, I mean, that's tough. If you're hit with that, on redirect, um, sometimes you just gotta like jump on the sword and, you recognize that was wrong, but does that, it's almost like, does that any way impact your ability to give this kind of opinion in this case? It's tough. Look, I mean, I don't have a exact answer for you on that one. You just got to hope the expert, can say, yeah, we shouldn't have done that. We were, trying to build the business. We were trying to, develop this, but that doesn't take away. I don't like that shouldn't harm my client's ability to get justice, right? I mean, that's at the end of the day what you're hoping for. What do you do if defendants lie and fabricate alleged conduct of, well, so if the defendants lie and fabricate alleged conduct of your plaintiff, then you shove it right up their ass. I mean, there should be that you should be able to hammer them for that. If they're saying your plaintiff did something in their background that is a lie, then you hammer their experts to say, did you see any evidence of this anywhere? The defense, and what we do is we'll say, the defense attorney said this X, Y, and Z in opening, or they're insinuated this, this, and this. Have you seen any evidence of that? So are you saying what they're saying is not true? Like they made that up? Did you see any evidence anywhere? And you reviewed thousands of pages of records. You see that anywhere? So that's not true. Is that true? Is that what you're saying to this jury, that what she said is not true? I would like go all out on that, to really hammer them. So I know we're kind of over time. I apologize for that. Teresa kept talking too much, so I'm sorry, guys. You can blame her. But anyway, please feel free to email us. These are our email addresses. We have a ton of samples. We can make your life easier, and we've probably seen it. We try a lot of cases throughout the state of California. We love being in trial. We've seen all the moves from both sides. And so we'd be happy to help or give any advice we can. So thank you, everybody. We really appreciate it. Thank you to the Beverly Hills Bar Association for putting out this trial series. And thank you, everyone. Get out there and try cases.
Bye, everyone.